Right away, this hearing is getting serious. The judge isn't dealing with just one charge. She's sorting through multiple robbery cases, an assault on a peace officer allegation, and probation issues all at once. That's a huge red flag because every new accusation can make getting bond much more difficult. Keep watching, because this decision could determine whether the defendant walks out of jail or stays behind bars for months. Next voice.
It may be one of those.
So, Mr. Smith, on Jeremiah Branch, I have a new offense of 26 DCCR 1168. Is there something else coming, or is that?
I think that was the new one, Judge.
Okay, I thought there may be two. I may just.
So, your Jeremiah Branch?
Well, there's 26 DCCR 0958 and 26 DCCR 1168, the two new cases.
I've got Mr. Kimler on one of those new cases, but not the Mr. Kimler.
Not the latest.
Yeah, I don't have.
1168 is the latest one. He was also indicted 3 weeks before that on a aggravated robbery.
1168 is what I don't have.
Yes, I have you right.
That's the one I'll he's taking up. I'm sure.
Okay, thank you. All right. So if you'll get a notice filed on that, Mr. Branch is charged with aggravated robbery, assault on a peace officer, robbery, and then the last one is another robbery allegation. What is the announcement?
He has a bond, I suppose. There's an MTRP.
Have you filed a motion for a bond, or what do you?
We're asking for a bond on the MTRP. MTRPs.
Did she print out the orders on that?
This testimony is more important than it may seem. The defense isn't trying to prove innocence here. They're trying to convince the judge that the defendant can realistically make bond and comply with release conditions. But here's the big question. Should medical issues and financial hardship outweigh repeated criminal allegations? Let us know what you think in the comments.
Is that this? Okay. So clause number is 25 DCCR 1382, which is an assault on a peace officer, and 25 DCCR 1385, which is a robbery, are both motion to revoke probations. And there are no bonds currently set. Is that correct in those cases? And Mr. Kimler has filed a request that I set a bond in each of those cases. It's like there's been a first amended filed in each of these. So he was placed on probation February 3rd of 2026. In both cases is 10-year deferred probations, and the allegations are a new aggravated robbery from April of 2026, testing positive for cocaine on several occasions, failing to submit to drug or alcohol screening on several occasions, failed to comply with Texas Drug Education Program, a new offense of evading arrest or detention from February 6th, resisting arrest or transportation February 6th. And so, Mr. Kimler, you may proceed.
Well, Your Honor, they're deferred adjudicated probations. We would just request to reach with MTRP bonds. If the bonds are denied, we would request a disposition on the MTRPs within 20 days and request for the bond pursuant to the Code of Criminal Procedure.
Is there any evidence with regard to your client's ability to make a bond, or?
Well, Your Honor, I think he's entitled to a bond. I haven't filed a writ to challenge the amount of the bond because it hasn't been set yet. So I'll wait for the court to set the bond. If that's excessive, then I would follow.
If I'm going to set a bond, I need to have information on what his ability is so that I don't set one and then we're back in here.
I can elicit that.
Raise your right hand the best you can, please, sir. You swear affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
All right, go ahead.
Mr. Branch, please inform the court of your current financial situation.
I get a $1,000 every month and disability.
And other than that, do you have any income?
I have food stamps And I was gonna, look for a part-time job too.
What is your disability that prevents you from working?
Seizures, but they told me I could work like, I could, work like 3 to 4 hours a day.
Go supplement your,
Yeah,
you have any assets, you own your own car?
no, I don't own my own car.
Uh, are you, are you,
My mom gave me, my mom not able to give me a ride.
are they giving you medication at the jail?
Yeah, they just put me on the new medicine and it's been working good. Everybody in the dorm say I haven't been having seizures or outbursts.
What medication are you on?
I've been trying to get the name of it, but I try to ask my nurse the name of it this morning, but I was sleeping.
Are you functioning okay now?
Yeah, I'm functioning way better than now. I haven't, but when I got here, when they first booked me in, I had like they definitely in the booking was on the booking, the front booking for like 4 days, and I had like 5 seats in there.
If the judge grants you a bond and you're able to get out, would you follow up maybe as a condition of your probation or condition of your bond with MHMR
Yes, sir.
to continue the treatment?
Yes, sir.
And as far as your other financial assets, you don't own your own car, do you rent, or where do you live?
I stay with my mom.
And your monthly expense is about what it is as far as.
That's a major ruling. The judge rejected the prosecution's request for no bond, but she didn't go easy either. Setting $300,000 bonds on each case, along with GPS monitoring and house arrest, sends a clear message. The court believes public safety is a serious concern while still preserving the defendant's constitutional right to seek release.
She pays the bill and I'm on food sale.
Last one.
No questions, Judge.
Okay, so for the record, I'm taking judicial notice of the court's files in all of the cases. And so give me just a second that I'm right now going over the probable cause affidavits and those 2 new offenses. Then I'm gonna do something else as well. Any witnesses, Mr. Smith, or just argument?
Just argument.
All right, give me just a second then.
Oh, my dude.
Yes, ma'am.
Almost there. Give me just.
Yes, ma'am.
Also reviewing the precinct report from the 2 cases where he was placed on probation as well in January of this year. So there was already information when he was placed on probation in January with regard to some mental health issues, and that was addressed. So he was placed on the mental health caseload. So it looks like that's not a new information that he had some. Okay, Mr. Smith.
Judge, I understand that these are deferred cases, but the state is opposed to setting bond based on the nature of the crimes that he was on probation for and the nature of the crimes that he committed within 2 months of being placed on probation for these first robberies. He, on top of the 2 felonies that are filed, there's also evading and resisting that are pending in misdemeanor court. He has failed several drug tests. He's refused to take other drug tests, indicating to me that he is probably under the influence of illegal narcotics most of the time. And for those reasons, I believe he is a danger to our community, and I would request no bond in these cases.
I would just add, Your Honor, if the court refuses to set a bond, requesting us disposition within 20 days of the MTRPs.
So here's what I'm going to do, Mr. Branch. So the underlying offense that you're on probation for is a robbery and an assault on a peace officer. And the robbery occurred at Delaware Food Mart when it.
This is the turning point of the probation hearing. Judges often look for one thing above everything else, whether prior opportunities actually changed someone's behavior. According to the record, this defendant received treatment programs, counseling, and multiple chances over several years. The question now becomes, when does rehabilitation give way to incarceration?
And attempting to steal, assaulted the clerk, and then they held you there while the police got there. And here we are 2 months after you got placed on probation, or 3 months after you got placed on probation for a robbery of a store. And we've got 2 additional robberies of the same store 3 days apart that are alleged. So obviously I agree with Mr. Smith. I think that you are a danger to our society. I am going to set bonds. I'm going to set bonds in each of your cases at $300,000. Conditions of those bonds, if you make them, are that you are on house arrest with a GPS monitoring device, and then we'll set your case for the appropriate hearing. Right?
Thank you.
Thank you. You are Ebony Broussard?
Correct.
And
Yes.
this is cause numbers 19-32518, 19-32806, and 21-36615. Ms. Broussard is on probation.
Notice one important legal detail here. Even though multiple prison sentences were imposed, the judge ordered them to run concurrently, meaning they'll be served at the same time instead of one after another. That can make a significant difference in the total amount of time someone actually spends in prison.
And the 32518 and 32806 was put on probation January 21st of 2020. 10-year deferred probations. One was escape while arrested, and the other was the second-degree assault on a peace officer, and then was placed on probation July 12th of 2021. And the clause number 21-36615 for a 5-year deferred probation for a state jail felony offense of possession of a controlled substance. She was here previously, entered pleas of true to counts 1 through 5 in that motion to revoke in each of the cases. There was no agreement. I received the pre-sentence report update. Have y'all both had an opportunity to review that update?
I have, Judge.
Are there any additions or corrections or anything on that?
Judge, I have just a quick comment. I'd also like to ask Ms. Richard or Ms. Fenton if they have anything for the court. They've been very involved in this case.
Anything that's not in the report that you think is important?
No, Your Honor, everything that we have in there is very direct in support.
All right, thank you.
And my only position, Judge, would be that she's obviously been extended almost every opportunity that probation has, every class, every structure, every program, and it would not be the position of the state like it typically is to argue for safety. In fact, I would argue strongly against it.
All right, Mr. Kimler.
I suppose, Your Honor, in response to that, she has demonstrated an ability to complete the programs, which is reflected in the pre-sentence report that she has been ordered to attend. Of course, there is a pattern of conduct that reflects addiction and substance abuse. But she
What an incredible contrast to the earlier case. One defendant leaves facing years in prison, while another walks away with deferred probation and a chance to erase a felony from his record if he follows every condition. It perfectly shows how sentencing isn't based on one factor alone. Judges weigh criminal history, rehabilitation potential, public safety, and personal circumstances before making these life-changing decisions. If you were the judge, would you have made the same calls? Let us know below.
also has the ability to complete the programs as well. I don't know how that relates to her inability, I suppose, to cope with the substance abuse issues, but she does have the ability at least to have enough structure and conform to the structure of these programs to complete them. So that says something. It looks from the pre-sentence report, it would be asking a lot to continue her on probation, especially with probation probably being unwilling to, or at least reticent to do that. I would only ask the court if the court is considering for the developer to consider something at the lower end. She does have children. And I'm not trying to use that as an excuse or anything, but they could maybe perhaps,
Children she was on her way to get while she was under the influence of PCP.
I don't know that they established conclusively that she was under the influence. I mean, again, it reflects the substance abuse problem, but she
She
does.
played true to all of the counts.
But yeah, that's true, Your Honor, and it reflects a continued struggle with substance abuse.
Yeah.
And so the issue then is going to be I'm looking probably incarceration, but I would just ask that it be something not extreme, or at the upper end. And she wanted to address the court. What do you have to say?
I do take accountability for my actions, but however, I have completed ISL before. And if you will be willing to work with me again, I would appreciate it. I have, before was incarcerated, I did enroll myself in outpatient classes, which was referred to me through Ozark when I got assessed. And I was taking AA classes as well. I did complete 5 of the classes, however, I wasn't able to complete it because I was incarcerated. I do still have my job, and I did complete my 5-year probation for the first conviction. And I do pay my.
So is the time, it was told, I mean, because of the motion. So yeah, I mean, you did the 5 years, but
Yes,
it's
ma'am.
not over.
Yes, ma'am.
What is, Ms. Malfino, do you have any position with regard to specifically punishment on these cases?
Sorry, Judge, I was just thinking back of the original PSI. Yeah, I do, thanks. Obviously, the court sees that she doesn't, prior to this, have any type of felony conviction, Judge, so I'll defer to whatever you think is appropriate, just in the context that they have given her so much of their efforts.
So, Ms. Broussard, you've been given the opportunity of, it looks like you went to Franklin North way back in 2017. And then you get on probation. You went through JCDI, but you couldn't complete it because of progressive sanctions for continuing to not follow those rules. Then you went to Franklin North, December 7th of 2020. You were on the drug patch program. You did that. You went to anger management. You went through the moral recognition therapy. You were on the high medium caseload. You've been to ISF. And despite all of that, you're still on 2 probations, one of which you could get 20 years in prison and the other 10. You still haven't figured out how to stop using drugs. And you were in fact in a vehicle going to pick up your young children from daycare under the influence of PCP.
Oh, man. However, when I went to Franklin North, it was because I was in a toxic relationship. And that's what they did.
So, but here's, okay, how old?
And
How old are you?
I'm 42, man.
Okay, so you've been through what appears to be years of drug addiction. And at 42 years old, and you've been on these probations for 5 years or more, you've had every opportunity handed to you to try to help you, and you're still using. So at this time, in clause number 19, 32518,